Okay, I think we'll get started. I believe we'll still have a few more participants joining as we go along, but good morning, everybody. Thank you for joining us. If you don't know me already, my name is Steve DiTullio. I am one of the partners in our employment relations group, and I'm very pleased that we're able to do this HR roundtable through a webinar format for those of you in attendance this morning. John Gardner is my co-presenter. He's having some technical difficulties this morning with his computer, so he may pop in. We had divided up this presentation. If he pops in, I may hand this back over to him right away if we're on his section. If we're on my section, I will just continue with the presentation. Just one administrative housekeeping, actually two. First, this is scheduled to go until 9:30, but we also have built in some time for Q&A. And the way we're handling Q&A is do it in writing, please. For those of you that have been on webinars with a lot of attendees, and we have a lot of participants this morning, I'm trying to do it by verbal method. It's difficult, as I'm sure many of you can understand. So if you do have a Q&A, I encourage you to just populate that through the Q&A tab. Go there. We will check that occasionally. We may answer a few questions during the presentation. Otherwise, we will answer them at the end. And with that being said, I don't see John, so I will begin with a couple of comments from his section. And before I talk about an overview, I just want to mention that the last 3 months have really been different for all of us, right? In our personal lives and our professional lives. The workplace has changed and faced a lot of challenges and opportunities in some ways. And we'll be talking about sort of as companies bring employees back to the workplace, what are some of the challenges? What are some of the concerns? What are some of the issues? That is the purpose of today's presentation. Over the last 3 months, I've done numerous webinars, and John has as well. And early on, it was more talking about furloughs and layoffs, and then FFCRA came and PPP loans. And so we sort of morphed into those new laws or legal programs so that employers, businesses understood those. And then from there, it's sort of morphed into the issues that seem to be coming up regularly for employers. And then we're now at a stage where most of the calls that I'm receiving are not about FFCRA or PPP loans. It's about returning people to the workplace and issues related to that. That's why we thought it would be appropriate to do this presentation. So that being said, just a quick overview. As I said, COVID-19 has changed just about everything in our lives. Some of the things we're going to cover during this presentation today that have arisen as a result of the sort of working and running a business in the current pandemic era, a business or a nonprofit for that matter. I see John just joined us, and you're on mute. Hang on 1 minute, folks. Well, I'm going to continue until I can see that John is able to join us verbally as well. John, are you there?
Steve, can you hear me?
Okay, now we can. Now we can.
All right.
Okay.
All right.
So I just did a brief introduction and was about to go into your first bullet point on the overview. So I'm going to hand it back to you, your section, and go with it.
Gotcha. Well, sorry about that, everybody. Of all mornings to have computer problems, this is the morning.
John, you're very quiet. John, you're very quiet.
Of all mornings to have computer issues, this was the one that happened to me. Can you hear me out right now, Steve?
Yes.
Okay. So I'm actually calling in on my phone because my computer is still not functioning. So hopefully this will work out okay. But in any event, I guess this is the joy of technology. And thank you guys for being patient with my issues here. And hopefully this will run relatively smoothly from here on out. I was going to make some crack about how 2020 was amazing and how now the world is being dealt with in webinars. I didn't expect that on my way to trying to join on the presentation, I was going to run into this issue. But in any event, thank you all for joining on, and thank you for coming here to go ahead and pay attention to our webinar. I know Steve's gone through some of the basic introductory stuff already, but I wanted to go ahead and touch on just a couple of notes here. So as you see with this first slide that we've got here, the pandemic has obviously changed dramatic aspects of how we live our lives, certainly in just society in general, but also for employers and employees. And we want to go ahead and address some of the more sticky questions that employers have been coming across and that we believe they will come across as time goes on here over the next few months and even throughout the remainder of the year. So as this slide shows, we wanted to go through, what can employers do? What should employers do when you're faced with employees who are requested to come back to work, but for whatever reason don't want to? What options does an employer have? And as we're going to get into here in a little bit, there are issues that pertain to the Families First Coronavirus Response Act, the FFCRA. There are issues relating to the FMLA. And there's also issues relating to reasonable accommodation under the Americans with Disabilities Act and the Wisconsin equivalent, the Wisconsin Fair Employment Act. So these are all things that should be considered, certainly when you're faced with a scenario like that. But also, as Steve's going to get into a little bit later on, you're going to want to pay attention to unpaid leaves of absence, whether or not those could be useful even when they're not legally required. And, in addition to dealing with this particular problem of having employees coming back to work or refusing to come back, Steve in particular is going to get into some various return to work issues, including travel policy issues, work plans, etc. Can you go to the next slide, Steve? And he's also going to get into, when can you go ahead and ask employees about testing? How should you go about doing that, especially with respect to temperature exams, etc. He's going to get into various different issues involving OSHA. And then at the end of the presentation, we're going to come back and I'm going to talk to you about potential legal issues that could come from dealing with the pandemic, potential liability issues that could come up. So yeah, next slide. So again, what I kind of set up already is what happens when you're faced with an employee that does not want to return to the workplace. And really, I think the order that you see set out here, these 4 steps, is kind of, it's a good order to go ahead and try to determine what's best to do in a given situation. See what laws might apply first, and then try to determine, even if there aren't laws that do apply, what considerations should you as an employer try to look into. And so the first thing that we've got here is, does the Families First Coronavirus Response Act, the FFCRA, does that apply? Steve, can you go forward one? And so, as you are all aware right now, the FFCRA has 6 different buckets of leave that could potentially apply. The first bucket is, is there a quarantine order in place that makes it impossible for the employee to work? The second one is, has the employee been advised by a healthcare provider not to go into work for risks relating to COVID-19? The third one is the employee is suffering from some type of symptom relating to COVID-19 and is seeking a diagnosis or has gotten a diagnosis. The fourth one is the employee needs to care for somebody who has COVID-19 or has some type of symptoms and is seeking a diagnosis. And then the fifth one, which is really the last one that we need to discuss, is, is the employee a parent of a school-aged child, and does that child have no school? Has their school been shut down as a result of the pandemic? Now that we're really entering into summer, has the child's child care otherwise been canceled as a result of the pandemic, whether it's a summer camp or otherwise? And, if so, is that person entitled to leave, the employee entitled to leave because they have to take care of the individual or their kids? There is a sixth reason as well, which is kind of a particular provision that the federal government left open in connection to this law, so that if there are different conditions that arise that might be somewhat related to COVID-19, they can just go ahead and amend the law or put out some regulations saying that this additional condition will also satisfy the law, so that they don't have to pass something else. All of these things are things that you should definitely go ahead and consider. And really, I don't want to spend too much time going into them on detail. Steve and I have already given webinars on it. I'm guessing if you guys haven't seen those webinars, you've probably seen plenty of other materials on the FFCRA. We are certainly happy to answer any questions that you might have relating to those. But I don't know that we need to go into it in much further detail right now, except I do want to mention the summer camp idea here. Obviously, again, as schools are shutting down, and this remains true for my kids, I've got an 8-year-old and a 7-year-old at home. We had some camps that were canceled, and I'm sure there's going to be employees out there, if not some of you in the audience yourselves, who also have kids are going to be in that same type of situation. And so when that happens, that fifth reason for leave, that the parent needs to stay home to take care of a school-age child could still apply. So that's something that as employers, you're going to have to be aware of as this summer continues. And certainly when we get back to school in the fall, at this point, we don't know what form school is going to look like. So it's entirely conceivable that we're going to have some additional situations where parents of school-age children may need to take time off pursuant to the FFCRA. I think I heard a rumor of a plan in one of our local school districts here a couple of days ago that they might do something where they reduce the number of kids in school at a given time and give certain blocks of kids 2 weeks on and 2 weeks off, which obviously is going to wreak havoc with the schedules of any parents who might otherwise have to go ahead and take care of those kids. So these are things that, even though the school year is done, for now, these issues are not going to go away, and we need to continue to be cognizant of circumstances that may arise. Next slide, Steve. Thank you. So the next step in the process is to go ahead and see whether or not the FMLA, the Family Medical Leave Act, or the ADA, the Americans with Disabilities Act, or its Wisconsin equivalent, the Wisconsin Fair Employment Act, may apply. So let's focus for a couple of minutes on regular FMLA. Obviously the FFCRA expanded FMLA for that childcare reason that I was just going into. And as a unique aspect of the FFCRA, that law actually applies to employers that have fewer than 500, but the 50 employee threshold that we're familiar with for regular FMLA doesn't apply. Well, obviously, when we're talking about regular FMLA, FMLA under regular non-Families First Coronavirus Response Act circumstances, then you still need to have the 50 employee threshold at a given workplace in order for you, the employer, to have to respond to it. So obviously you as the employer need to look into whether or not you actually need to comply. Then, once you cross that threshold, which you should be aware of by now, you need to see whether or not this employee who is refusing to come back to work may have some type of a serious health condition. And I think Steve and I have been talking about this before, and I think there's probably a few different areas in which somebody with COVID-related concerns could have a serious medical condition that would actually qualify him or her for FMLA leave. One that I think is relatively obvious is if the person actually has a COVID-19 and suffers some type of complication from it. That certainly will be considered a serious medical condition under the FMLA and entitle that person to leave even after the FFCRA leave, to which they may also be entitled, would run out. And one thing that I'll probably reiterate again, because I think it's relatively important, is as an employer, you should try to deal with all of these leaves at the same time, because you might have various different circumstances where somebody who qualifies for FFCRA leave also qualifies for FMLA leave. And to the extent that you can try to run those at the same time simultaneously, you should, because the alternative is conceivably you could end up giving an employee the right to some leave that he or she is not otherwise entitled to. For instance, you might have to give somebody 2 weeks of FFCRA leave, but then if you didn't go ahead and do the analysis and didn't fill out appropriate paperwork as to whether or not that leave also satisfied the FMLA, conceivably that employee could still get another 12 weeks after the FFCRA leave is done, for a total of 14 weeks, with respect to which, under laws, using them in the way that I think as employers we can, you would have been limited to 12 weeks of protected leave that you would have had to provide. But again, COVID-19 itself, I think, could be a serious medical condition. But I think there are also other circumstances where an employee has some type of an underlying medical condition that makes him or her more at risk for suffering from COVID-19 complications in the event that they are exposed. A couple of things that come to mind: maybe an underlying heart condition, maybe some type of, if they have cancer and they're undergoing treatment, anything where the immune system might be somewhat compromised. And of course, there's bunches of other examples as well. But I can certainly see the possibility where a doctor or a healthcare provider will say, this person is not able to work in the work environment as they understand it, in a workplace with other people or in close proximity to other people, because the risks are too great. And then as a result, that employee may be entitled to take unpaid leave pursuant to the FMLA. And, again, as I mentioned, this is unpaid leave. The employer does have several obligations with respect to that leave, including continuing the employee's health care insurance at the same level and with the same payment plans as before. And obviously, this leave is job protected, as are all of these leaves under federal law. But this is definitely something that you as employers should remain cognizant of. Steve, can you go to the next slide? So, once we kind of go through the FMLA analysis, you'll want to go ahead and take a look at the reasonable accommodation analysis. And again, this is something that you could be doing simultaneously when looking at all of the other laws as well. Now, I don't think, unless somebody has severe complications from COVID-19 that last for a really, really long time, I don't think we're going to get to the point where having COVID-19 in and of itself is a disability. I think, usually temporary conditions are not considered disabilities. They have to be something that is relatively long term. But again, I think here is where we're looking at, is there an underlying condition that can perhaps make or put somebody who has an existing disability more at risk with respect to COVID-19 exposure? So, we need to kind of start at the beginning, similar to what I was just explaining with respect to the FMLA with the ADA. You need to see whether or not it applies. The ADA itself applies to employers who have 15 or more employees. But even for those of you in the audience who are smaller employers, the Wisconsin equivalent, the Wisconsin Fair Employment Act, is going to apply to you if you have as many as 1 employee. So you're not out of the woods. Again, autoimmune disorders, people who are undergoing cancer treatments, people who may have liver issues or kidney problems, people who might be diabetic. I can see plenty of situations where an employee who might fall into one of those categories says to his or her doctor, look, it's this prospect of going back to work. And the healthcare provider may agree and say, as a result of your condition, I don't think it's safe for you to go back to work. Therefore, I think the employer should go ahead and try to accommodate you so that you don't have to go back to the workplace. Now, maybe there are certain reasonable accommodations that the employer can go ahead and consider to avoid having an employee telework if that's not something that you as an employer are able to consider beyond what you may have done already throughout the Safer at Home order when that was in place here in Wisconsin. And so on the screen, you see that there are some types of accommodations that Steve and I have already come across that you might want to consider. One of them is working at home, and I'm going to talk about that in a little bit more detail. But you could also consider changes to the working environment, including having people wear masks in common areas. I think that's already been suggested by the CDC, and I think Steve's going to come across that again later. Having plexiglass dividers where appropriate, trying to space out workstations so that they are at least 6 feet apart. There's a lot of things that you can consider, and perhaps by doing one or more of these things, even if you have an employee who is reluctant to come back, maybe by offering one of those reasonable accommodations, you will convince him, her, or their healthcare provider that whatever accommodation you are providing is appropriate and will actually satisfy whatever concerns they have. As the employer, and this is something that I know I've said in numerous previous presentations, you as the employer have the ability to choose what reasonable accommodation to provide, so long as that reasonable accommodation actually enables the person to perform the essential functions of their job. So if there are 2 or more different reasonable accommodations that actually satisfy that definition, you as the employer can choose the one that you want. That is an important piece here. But obviously, there may be some circumstances where not every single reasonable accommodation or accommodation that you think might work is going to satisfy the healthcare provider's restrictions. And so you may have to consider further working from home if you've already allowed it. You may have to consider some type of an unpaid leave. Steve, can you go to the next slide? So really, like you've been used to for probably a couple of decades by now, depending on how long you've been in your position, this type of analysis does call for engagement in the interactive process. You've got to reach out to the employee, try to engage him or her and their healthcare provider in a dialogue to determine what type of accommodation may be appropriate, and even to determine, if an accommodation may be appropriate. One thing that I've kind of already alluded to, but certainly is going to come up, is the idea of telework or work from home as a reasonable accommodation. Obviously, there were many of you in the audience who had employees, frankly, like Steve and I, who have been working from home for an extended period of time, who were not used to doing that beforehand. And maybe some of those employees were actually able to do this work and do it in a very efficient manner, perhaps as efficiently or maybe even more efficiently than they were doing when they were in the workplace. With employees who fall into that category, it's going to be a lot harder now to say that working at the workplace is an essential function of a job. If you are, as an employer, you have the ability certainly to try to show that there are certain aspects of the job that perhaps the employee was not doing appropriately beforehand. Maybe there are certain things that they were failing to do when they were working from home that working at work would cure. But if you have an employee who is working almost as efficiently as before, or even more so, it's going to be very difficult, I think, to go ahead and tell that employee that working from home for a longer period of time, at least during the crisis here, is not a reasonable accommodation. There will certainly be arguments that an employer can make and say, well, we made an exception when the safer at home order was in place because otherwise a lot of us had no options because we weren't considered essential businesses. And that argument may very well fly. But I can certainly see some enterprising plaintiffs' attorneys, if they have some type of an employee, a client, who they think has been wronged by not being able to continue working from home, I can see those arguments coming up. And that's something that we as employers and as employer representatives need to be cognizant of. Now, one thing that I do want to mention before moving on is the second bullet point on the slide, and that is, just as before the pandemic, just as will be the case after the pandemic is over, employers do not have to provide reasonable accommodations that actually cause them to incur in undue hardship. The undue hardship analysis is frankly not the easiest thing for an employer to demonstrate. And unlike most circumstances here where the employee is going to have the burden to demonstrate that the employer wronged them in some fashion, employers actually have the burden to demonstrate that a particular accommodation is going to be an undue hardship on them. And certainly you can point to things like you would think of, like it's going to be too expensive to do, or it's going to adversely impact the work environment if we permit this accommodation, or some assignments are going to be missed, or the workflow is just not going to work the way that it was before. These are certainly valid considerations to consider. But what I would recommend, and I know what Steve would recommend, is that if you are considering denying somebody's request for a reasonable accommodation on the basis of an undue hardship, definitely consult with counsel before you go ahead and do it, because it is risky. I mean, it does exist as an argument for employers to fall back on, but it's kind of tricky to wade your way through it. So I think it's important to get counsel involved if you are going to do it. One thing that I just wanted to mention here, and I know Steve is going to go ahead and address this here shortly, but you also need to be careful with respect to employees who may not have any type of an obvious disability, or who really just don't reach out to you as an employer and request some type of accommodation. I've talked with some clients who have been, I think, rightfully concerned about the health of a given individual, because they happen to know that he or she falls into some type of at-risk category with respect to COVID. We need to be careful not to make decisions for these employees, because if we do so as employers, we can subject ourselves to claims of discrimination that we don't want to deal with. And so even though I know concerns like that come from a very good place, and obviously I have them too, and Steve has them too, that's an area in which we need to tread somewhat carefully. And I know Steve's going to touch upon that here in a little bit. Steve, I think I'll pass it on to you.
Sounds good. And we don't have any questions yet, so I'll just jump right into my part. So as John said earlier, the starting point of the analysis as to returning employees to the workplace is always the statute, FFCRA, FMLA, ADA, which is what John just went through. What I'm going to go into now are just some other circumstances that have been coming up. Some of these involve judgment calls by the employer as to what you do. Many of them do implicate certain legal issues as well, obviously, but some of them are judgment calls from an HR standpoint. So let me just hit a few of these, and I am sure some of these are going to be things that you all have either dealt with or have thought about. And the first one, and I've worked with numerous clients on this issue, is somebody says, I'm scared of COVID-19 in the workplace and I want to continue my unpaid leave, and the first 3 bullet points I would put in the category that both unpaid leaves of absence or continuation of telework, it could apply in either of those circumstances. So what you have is somebody who doesn't have the underlying health condition that John was just talking about, doesn't have COVID-19, is not showing symptoms, anything like that. They just are scared, like numerous people are, of COVID-19. They don't want to expose themselves back to the workplace. So they could say to you, I'd rather just stay on an unpaid leave of absence. Or, I've been working pretty well at home with this telework gig, can't I just continue this? And I would say, maybe. The answer to that one is maybe. Particularly well, let's take them one at a time. For an unpaid leave of absence, I think the biggest issue there is an analysis of your workplace. This might be an impossible thing to do, especially if you are a larger employer, but maybe if it could even cause some problems for a smaller employer. But you have to look at your workplace, you have to make some judgment calls, and can the company continue to be productive and efficient at this point in time with that employee staying in an unpaid, because we're presuming there's no FFCRA, there's no they've used up all their PTO, so it would be an unpaid leave. But there's a key question you have to ask yourselves with that one is, what's the impact on the rest of my workforce? Because if you allow Sally to continue an unpaid leave of absence simply out of fear of COVID, again, no medical conditions or anything like that, you may start getting other people who want the same type of treatment. And particularly if this implicates some protected class issues, you could start getting into discrimination concerns. What about continuation of telework for somebody that's fearful of returning to the workplace? That one, I would say, again, you have to do the same type of analysis. Can the company be as productive and efficient with that employee working in from home? And as John just said, there are many situations where people are more efficient or just as efficient working from home. And certainly there are other situations where people are less efficient. Those ones, I think that you have a much better argument and need to bring those people back. But it's something to consider. It's a judgment call in regard to continuation of working from home. Although, again, same issue. If you allow Sally or Ron to do it, will other people come forward and say, you know, I think I was pretty efficient at home, and then you do start maybe worrying a little bit more about production and efficiency concerns, that type of thing, and also consistency. So all of those things need to be considered. Could it lead to a discrimination claim? Yeah, if it's not handled properly. But I have worked with some employers that are just taking a bright line rule and just saying, we're not going to allow unpaid leave. We're not going to allow continuation of telework. We want people to be back in the workplace, and they do some type of a transition plan where not everybody's coming back at once. Is that okay? Sure, that's okay. But it's just something to think about. One key point about this is fear of COVID-19 in the workplace is not something that you have to consider as a basis to accommodate unless the fear is so crippling and the person has gone to a mental health or a physical health doctor who's diagnosed them with anxiety or something of that nature. Then it does go back to John's analysis about reasonable accommodation. Second point, age over 60. I've had so many employers come to me and say, hey, Steve, why can't we just adopt a rule that says, you know, we're doing this to protect our older folks. You know, we have a number of people in 60s or early 70s, and we want to make sure that they understand that because they're in a higher risk category, they don't need to come back to work if they if they're either fearful or just are not at a point where they're ready to come back to work. The issue with that is, even though it's well-intentioned, this is sort of following up to John's comment, and remember, with people over 60 or over 40 for that matter, where the age cutoff is under federal and state law for discrimination purposes, you don't have any reasonable accommodation requirements for age. That's a disability and a religious basis that you have to do accommodations, not age. The EEOC has sort of flip-flopped a little bit on this in the last month. They initially put out some indication that maybe an employer could adopt a policy of some sort, and then said, that's probably not a good idea. And I agree that that's not a good idea, because if you adopt a policy that says, if you're over 60, you don't have to come back to work, you know, at this point in time, you may get a older employee saying, wait a minute, you're treating me differently. You're singling our age group out on the basis of nothing other than age. It's a little bit embarrassing. It's disparaging of my ability to make my own decisions. You don't need to make that decision for me. You're not making that decision for somebody who's 30. Why should you make that decision for me? That could be an age discrimination claim. So my recommendation on that one is don't adopt a policy. However, if you have people who are in an older category that express that because they are at a higher risk, and again, we're talking about people that have no underlying medical conditions, which is less likely as people get older, but let's assume there is no underlying medical conditions. I would say you should deal with that on a case-by-case basis. And again, a little bit of a judgment call in regard to how the rest of your workforce would view that. My view is, you know, if a 35-year-old in your workplace doesn't understand that you have a 72-year-old that's clearly at a higher risk and should be allowed to continue working from home, that is probably not the most reasonable view of that. And I'm picking on a 35-year-old. It could be a 55-year-old. It could be somebody who's 59 that says, I'm going to be 60 in 8 months. So just think about that, but don't adopt an across-the-board, well-intended policy for somebody over a certain age. You may get this one. I've had a few of these. Additional unpaid time off after the FFCRA leave is done, whether we haven't seen that with the 12 weeks yet because we haven't gone through a cycle yet. But I certainly have seen this with particularly somebody who is taking care of somebody who is sick. And they want to continue because the person hasn't bounced back. They're still not better. What do you do with that situation? Again, doesn't it implicate any FFCRA at that point? They've used up their 10 days or a portion thereof. I'd say, again, you need to look at that and make some judgment calls. Try and apply whatever rationale on any of these, whether it's an unpaid or a continuation of a telework arrangement. Try and have some objective measurements if you can, but there is just going to be an element of judgment. Again, you could take the position that no, your FFCRA leave is what you get, and that's it. But it's something that just be aware that you may get those types of questions. The last bullet point really only goes to an unpaid leave of absence for the most part, unless you have somebody, I guess, in a telework situation, but in a reduced hour position. This could come up where they're getting partial unemployment comp. But as most of you are aware, right now unemployment comp is very generous because of the federal $600 per week kick-in that's been added on top of the Wisconsin benefit. You're probably not going to get an employee that says, hey, I just want to stay out. I'm on unemployment comp. I'm making more money than I was making when I was working for you. You're probably not going to get that, I don't think. But that could be something that is running through a person's mind. And not only are they maybe making more money, but they also don't have to go into work. They don't have to deal with the boss. They don't have to deal with potential exposure in the workplace. So if that is sort of your belief that may be at the core of things, and I had this come up. One employer called me and said, on Facebook, they posted something saying, I'm making more money, being in an unemployment comp status than I made before, like double or whatever it was. So there are people that put things out on social media or will say something to a coworker or to a friend and it gets back to you. So just be aware of that issue out there. A couple of easy ones, but it's still worth mentioning because they could become a little bit more difficult. So employee is tested positive 4 days ago. They haven't been cleared to return to work. That's easy. Obviously, you're granting them if they've used up all their PTO and there's no FFCRA, maybe they use that up to care for somebody else, that type of thing. You now are in a situation that the person could be put on unpaid leave until they do recover. And that is a very valid thing to consider, and I would encourage you to do it. How long should that run? That's where the issue could come up. Most people, but not all, you're looking at about 2 weeks or so. But like I said, this virus is different with different people. Some people get hospitalized and are incredibly sick, as we all know, for a couple of months. Some people die. Some people don't show any symptoms at all. Some people, it's 14 days. So you're going to have to be a little bit flexible with this. If you feel like, maybe the person's been at home, they haven't been hospitalized, 3-4 weeks have passed and they're saying, oh, I'm still not better. At that point, I would recommend ask for some medical documentation, because if somebody has not been hospitalized, but they're saying that they still have symptoms and are feeling sick, 3-4 weeks, that's longer than what, I at least I've seen from CDC and just talking to doctors and so forth. So it's fair to ask for medical documentation. Just make sure you follow what that medical documentation says and maintain any of that documentation, just a reminder, in a confidential and secure file. What if the employee making a request for unpaid leave, and these are unpaid leave situations now solely, because she claims that they're showing symptoms, but they haven't been tested or diagnosed. This was probably more common before tests were easier to get. And I'm not saying in every part of the state getting a test is easy, but in some parts of the state it is. They can be free and they can be just a quick drive up. So this probably isn't coming up quite as much because you can always ask an employee to go get tested. But again, if they're showing symptoms but there hasn't been a positive test, you can ask for medical documentation. And same thing, make sure you keep it confidential and secure. And particularly if this is going on for weeks, hey, I haven't been tested, but I'm still not feeling well, I have symptoms, and this has gone on for 5 or 6 weeks. At some point, you might want to be thinking that maybe you need to call the bluff, or find out if there is something to the medical condition. So just keep that in mind. And you may need to get a second opinion, although if you get a second opinion, you're going to have to pay for it. So that's not a strong recommendation, but in a certain situation, maybe you want to do that. Okay. What about accrued but unused PTO, vacation, sick leave? What if you have somebody in any of these categories that I've just been talking about that says, I'm just going to stay out on unpaid. I don't want to use my PTO or vacation or sick leave. I want to save that up. No. My view on that is no. If you, for whatever reason, decide to let somebody stay out a little bit longer, make sure they're using up their accrued PTO, vacation, sick leave. Okay, that's very important. And this is sort of a middle ground strategy that I've recommended to some people. Instead of giving an open-ended unpaid leave, what you could do is say, listen, we'll let you stay out a little bit longer, but as soon as you have used up whatever accrued PTO, vacation, sick leave you've used, you got to come back at that point, and you can't be on unpaid leave. That's sort of a middle ground strategy that has worked for, I know, a number of businesses. Also, just a reminder, if you do that, and this is a John issue, but FFCRA leave always has to come first before applying accrued PTO, vacation, sick leave. Okay, and this was the fourth item that John had mentioned in his introduction. You've gone through the statutes, you've gone through unpaid leave or telecommuting, all of that type, or teleworking, I should say. When do you terminate the employee? And there are going to be times that you have to decide to terminate the employee. One thing, you always have to consider ramifications on the entire workforce. Again, this goes back to, do we allow an unpaid leave, or does it make more sense that you give the ultimatum to the person that, notwithstanding that you're nervous about coming to the workplace, in all fairness to the other employees, to your coworkers, you need to come back by June 15th. And if you're not back by June 15th, you're going to be terminated. Is that an appropriate path to go down? Absolutely it is. Especially because if people don't come back, if you just allow everybody that wants an unpaid leave out of fear of COVID or some of the other reasons we've talked about this morning, it could create workplace morale issues, and it could create production issues. So again, judgment call on these things, but those are key points to consider. If you do decide to terminate, and again, I'm not saying you shouldn't, I'm just saying think about these and make sure you document well, as we always tell you to do. But think about that. What about if it's a critical employee? What if it's your number one salesperson who's been working splendidly from home for doing telework? You may want to just continue them, but then again, there could be reasons that other salespeople have come back, and that whole consistency issue you got to be a little concerned about. So, do you really go so far as to terminate that critical employee? Something you have to think about if they, are not coming back. You could get some potential disparaging statements about the company regarding inflexibility on COVID issues. Again, maybe this isn't a big concern to you, but for some employers, maybe especially in smaller communities, where you need to find replacements for people, which may be easier now given the high unemployment rate. But nonetheless, especially because you're not being inflexible on COVID, you're just trying to run your business. And you've probably given a lot of flexibility on COVID up till now. But just be prepared for those. And of course, there's a lot of talk that when things get back to quasi-normal, there may be a dam bursting of administrative claims and lawsuits being filed. Who knows? Maybe that happens in the employment area, maybe it doesn't. But certainly people could say, come up with some type of a discrimination basis, retaliation basis under the FFCRA, something like that. So just be cognizant of that and make sure that you've documented the rationale, the legitimate business reasons for the termination. Okay, we're going to move on to OSHA issues, and I do a considerable amount of OSHA work, which is why this sort of fell on my shoulders. So many of you have started the process of returning employees to work. Some of you may have even completed it by now, but most that I am working with, most clients I'm working with, they're somewhere in the midst of it. So I think it's important to understand the return to work safety issues and the reasons for having a written return to work plan. And I strongly recommend a written return to work plan. Now, keep in mind that your return to work plan should not be static. Make sure that you are considering amendments to that plan as circumstances change. In a couple of moments, I'll talk about masks. And just yesterday, thank you, Jordan Rolfing, if you're on, one of our associates pointed out to me that yesterday, OSHA put out a guidance about masks. Well, you should all be aware of that, and I'll be touching on it. I won't be going into the details of it, but you should be aware of that because that comes into play and may impact what you end up doing with your return to work plan. Again, and there's lots of other issues besides masks that this could apply to. What if things get worse? None of us want to see a second wave, but what if it comes? That may result in a drastic change or abandonment of the return to work plan. So just be flexible with it. But I do recommend putting it in writing for a couple of reasons. One, it is, I think, a great communication device from an HR standpoint for your employees. So that's number one. A second reason I think it's helpful, excuse me, is because it goes to the issue of under OSHA, the general duty clause. The OSHA is going to have some expectations that employers are making sure that safety and hygiene and social distancing and things of that sort are being done during the return to work phase and as people come back to work. So given that, you want to make sure that you have something in writing because OSHA will potentially ask about that. Now, one thing I will say right now, OSHA is not as, how can I say this? Maybe not as assertive or as, they haven't done a lot of audits or inspections and so forth. That may change, it might not. Given the current administration, there may be some limitations put on that. I'm not saying judging the politics of that, but that's just the way it is. I think there will be some increase in OSHA inspections, but maybe not to such a heightened degree. But keep in mind, your state officials can come in and they may, if they see a void, and there's more and more attention being made of this about OSHA not stepping up to the plate to inspect employers, you may get the state coming in to address inspection issues. So again, putting something in writing is a good thing to have to give to OSHA or state officials. If possible, again, a lot of you are probably doing this, but strong recommendation, it should be a phase in transition for your employees. It should not be that unless it's a very small workforce, possibly. Having everybody come back at one time, it tends to be better to have people come back in a staggered manner. So how you do that, it's going to be dependent upon your workplace, the number of employees you have, the layout of your office. Lots of issues come into that, but generally speaking, have a phase in. Consider whether your company will allow particular accommodations for certain areas. Again, I'm not talking about let's move beyond ADA accommodations, but what if you do have some folks, a small number, that have children at home during the summer because summer camps were canceled, as John mentioned, or you get back to September, who knows what the schools are going to be doing at that point. My guess it'll probably be some type of a staggered system, but we just don't know. So you may want to consider within your return to work plan addressing certain objective groups like parents with school-age kids less than the age of 14. This is above and beyond FFCRA issues. You might want to have something like that. Make sure your return to work plan sets forth meetings, distancing, and travel protocols. For meetings, social distancing should be happening. You should discourage people from congregating in hallways or in break rooms and that type of thing. All of this should be part of your return to work plan. Travel protocols I'll be talking about in a moment in more detail because I've had a number of asks about that. Make sure that the return to work plan adopts the health and sanitization protocols that's set by the CDC and other public health officials. The washing the hands, having hand sanitizer, all of those things should be addressed within your return to work plan. Okay, travel policy deserves a little bit more attention. So first of all, I'm not going to be talking about international business travel. It's really not happening. I don't think, or it's not happening on a widespread basis. Maybe it's happening a little bit. But for most employers, it's not even something being considered until sometime in 2021. So I'm going to focus on domestic business travel. And you should address it in your return to work plan. But again, be prepared to amend it depending on how circumstances change. It's not a static document. So reasons not to allow domestic business travel yet, and these are all valid. And I would put in the caveat, other than maybe in something that is absolutely 100% necessary. There may be a meeting that has to be done face-to-face, and it requires airline travel or a hotel stay. But I'm talking about more things that are not as viewed as much of a necessity. So, one thing is don't allow it yet because, frankly, it protects employee health and safety. As soon as somebody moves outside of their home work environment to a workplace environment, is there greater risk? Sure. I'm not saying there's an unacceptable risk. And this is all about measuring risk, right? That's one of the things you have to look at. But then if you take the next step, that you have people at work, they're social distancing, they're wearing masks in common areas, doing all that stuff. What about a business trip? Whether it's to go to a conference that they normally go to, or go to some type of a sales meeting that would make sense for it to be done in person. Keep in mind right now, Zoom and other video conferencing, case in point this morning, we're not doing a live HR roundtable, we're doing a webinar. That's being used extensively, and it's being used more and more, and it's being used successfully. By the way, using Zoom and other video conferencing may save your business a few dollars. Travel is expensive. So there are safety reasons maybe not to allow somebody or require somebody to get on a plane and go to Phoenix for 3 days where they're having, an uptick. Arizona's a hot spot now, but there's also cost aspects to it. So think about that. This is a big one. Potential workers' comp issues if an employee becomes ill with COVID-19 at any time during their trip. So keep in mind that for most situations, if COVID-19 strikes one of your employees and somehow they're able to show it happened in the workplace, it's most likely going to be a workers' comp issue, okay? Well, if you send somebody on a business trip for 5 days, I would argue any point during that 5-day trip, if they get sick with COVID-19, is a workers' comp issue. Now, maybe you could say, well, you know, they went out to a bar that we didn't want them to go to and we told them not to do that. Maybe you have an argument there. But people have to eat, people have to stay in a hotel, people, if they're flying, have to go through an airport. If they pick up COVID-19 during that business trip, I think it's a pretty good argument that it's a workers' comp issue. Keep in mind that if somebody goes to Phoenix right now, using that, which is a hot spot, and they become ill while they're there, or the state or the city says, nope, nobody can leave unless you travel by car, you know, we're shutting the airports or whatnot. This could get really costly for the company if they're stuck in a hot spot. So, you know, these are all reasons to think about, do you really want to jump full force into domestic business travel yet? Somebody gets sick or stuck in a location, they could lose some work time in production. Also, there can be morale issues for employees who are not ready to travel. Maybe they're ready to come back to the workplace, but they're not ready to get on a plane and be told that they have to travel to some location. Also, you have your coworkers who might not want to interact with somebody that's just been on a business trip to 3 different cities for the last 10 days. So there are morale issues you have to think about. Just want to look at the time. Okay, I'm good. Quarantine. I still get the questions, I think there's a misunderstanding that is somewhat common, that, you know, if somebody goes out of town, automatically there should be a 14-day quarantine. Well, I don't think there's an automatic with COVID-19, just about anything, okay? 14 days is not going to do it for some people. Some people may be shedding virus for 3 weeks or longer. So a 14-day quarantine is not necessarily what you need. But here's the bigger issue. If you do adopt a rule like that, if you travel, you tell the employee, if you travel, you can't come back to the workplace for 14 days. Well, that inspires confidence in somebody going on a business trip. You're basically telling the person that, you know, you're going out, you're facing a higher risk of catching a lethal virus, and you're not welcome back to work for a period of time after that. If I ever wanted to be a plaintiff's attorney, and I don't, I would welcome that kind of case, okay? It shows that the employer acted knowingly, and I would make the argument in an egregious manner that takes this outside of workers' comp. So be very careful, and I do not recommend that you have a travel policy that says, when you get back, 14-day quarantine. I think that's a mistake.
Steve, you actually have 2 additional questions on quarantine. If you look down in the Q&A box, one is whether or not you can quarantine an employee if another family member or person they live with has contracted COVID, and another is in response to board directors and workers' comp.
Okay, let me just look at these real quick. So I'll just read these. The first one is, while not a company employee, would a company board director also potentially have a workers' comp claim if they're required to travel for a meeting? The answer to that is no, because they're not an employee. They're not going to be covered by your workers' comp policy. But there could be third-party liability, so think about that. But it's not a board director is not an employee. And the
Yeah,
other
Steve, if I could just jump in on that, I think in that case, you know, the person not being an employee could expose the company to more liability. I mean, frequently we look at workers' comp as something that employers don't want to have to deal with, but really it protects employers from negligence claims that employees can bring. So if you have a member of the board who's attempting to bring a negligence claim, there's not going to be the workers' compensation bar. So instead of that claim being covered by insurance, you might have to just cover it out of your own pocket or other insurance that's not workers' comp. So something to keep in mind.
Yeah. I'll answer 2 more of these. And John, if you have anything to add to my answers, please jump in just
Sure.
like and then I'm going to jump back in, and then we'll hopefully have some time at the end for Q&A. What if an employee's spouse tested positive for COVID-19? Can an employer require them to self-quarantine? Well, the first issue there is you may have a FFCRA issue because that employee may be taking care of his or her spouse. So that may, give them enough time for the spouse to recover, and maybe 14 days has gone by and the person is symptom free and they get a test and they don't have it, and then they're able to come back. If you need to extend that a little bit, could you do that? Yeah, you could have. You don't want somebody bringing COVID-19 if they've been exposed into the workplace. It's a basic safety issue. So could you require them to quarantine or stay home for a longer period of time? The answer to that is yes, sure, you can do that. John, anything to add on that one?
No, I think you covered that well.
Okay, and maybe I'll just answer one more. Is there any current guidance that states that an employer needs to monitor employee vacation spots for quarantine purposes? No, there's no guidance. There's no CDC guidance on that issue or OSHA issue. However, as people during the summer do go on vacations, it is something that you're going to have to think about. I can't say that there's a one set rule I would recommend on this, but certainly if you find out that somebody went to a hot spot and went to a gathering of 100 people, family reunion or something like that, that is going to cause a lot more concerns than somebody that went to a state park in Montana and camped with their wife who didn't have any issues and saw very few people and drove and then came right back home. But as far as like some broader guidance about it, I'm not aware of anything like that. John, are you?
No, I'm not aware of any guidance either, but the points you made were good. And I think certainly employers can consider, do they want to perhaps tweak some of their vacation policies or their paid time off policies in light of the current situation where we are, so that as an employer, perhaps you ask employees, where are you going to go? Or at a minimum, at least reiterate that they should practice good social distancing concerns when they do go to places, and take into account CDC guidelines when they do. So at least you put some of the onus on them, and you as the employer are taking additional steps to perhaps protect other employees. Yeah. Obviously, you might have employees who just ignore all of that and then don't tell you anything. And I suppose it's going to be up to you in a given situation, or just kind of broadly, how far do you want to push people to go ahead and give you that information? But yeah, there are certain steps that you could take to try to reduce your risk.
Yeah, I totally agree with that. Like, for example, you could amend your vacation policy that says, if you travel by air rather than drive somewhere, that, you will be in an unpaid, quarantine situation for 2 weeks upon your return. That's an objective criteria. I'm not saying every company should do that, but could you have some type of objective measurement like that? Sure, you could do that. But to John's point, and this, by the way, answers, I think, the fourth question that came in, which was, should we have some guidelines around travel for personal reasons? I think you should. Okay, so let me continue about if you have if you do decide that you want to start going down the path of having employees travel, what you might want to do is have just like a gradual return to work of your employees, maybe have a gradual return to travel, which will be amended again if things get worse. So, what you might want to do is, for the months of June and July, don't allow any domestic business travel. Things are looking good. If the numbers still are looking good, then maybe you could progress to, allowing travel to certain locations and restricting any travel to hotspot locations, which, might require at the last minute a change in plans, but so what? Right now, I would not, again, to use Arizona, I would not allow an employee to travel to Phoenix or some other major city in Arizona, given the numbers that are going up there. And there's like 12 other states, I think I saw yesterday, that the numbers are going up. So I wouldn't call them hotspots necessarily, but you got to look at that and then change the travel as conditions develop. You know, travel by car, where somebody is maybe going from Madison to Green Bay and back, you know, that I think might fall within allowing that to happen early on, especially if they're going to a destination where social distancing is done. And I would say wear a mask if you're in a meeting. And believe me, the mask is going to be a big issue going forward because there's different views on wearing of masks. But I do think that, like with the OSHA guidance that came out yesterday, and also CDC, that there's some legal risk if you don't underscore the need for a mask. If an employee is scheduled to travel to a location, again, and it becomes a hotspot or certain infection conditions crop up, just reschedule the trip, unless it's absolutely necessary. Just a few final points in travel policy. I would say if they are traveling, particularly on an airplane and in the airport, you know, think about the use of masks, gloves, although gloves are a little bit more questionable just because people may touch more surfaces because they're wearing gloves. But right now, that is a PPE thing to at least consider. And, you know, I would say tell them that they have to bring hand sanitizer with them, remind them about washing hands, all of the things that you do in your workplace. Make sure that you are doing and requiring when they're traveling. Yes, it's much harder to enforce. I get it. I totally get it. But it doesn't mean you shouldn't require it, because that is another point in your favor if OSHA or a state official were to take a look at your return to work plan and what you're doing to protect employees. It also can help protect you if there are claims that are outside the exclusive jurisdiction of workers' comp. Let's see, what else do I want to cover here? Again, there are judgment calls related to personal travel. There's judgment calls related to business travel. Key point, liability risks are unknown right now, so they can be significant. So just be aware of that as you decide what to do with the travel policy. I can't sit here and say every company shouldn't allow travel. That's not what I think either John or I want to do. You have to just look at the circumstances for your business, your industry, your particular employee within the context of what's happening with the virus. Okay, OSHA compliance issues. Some of these I've touched on already. The three key ones: general duty clause, possible need to include COVID-19 cases in OSHA logs, and PPE requirements. I want to leave room or time for John, so I'm going to go through these fairly quickly. Again, I think all of you are aware by now there is a general duty clause under OSHA that requires you to furnish a place of employment free of hazards that could cause death or serious physical harm. Can COVID-19 cause death or serious physical harm? Absolutely it could. And OSHA has made clear this applies to COVID-19. So that means you need to establish that you've implemented certain safety and hygiene protocols and procedures that are keeping your employees safe. So putting it in the return to work plan, reinforcing it through posters in the workplace, putting something maybe temporarily in your employee handbook, all of those are good ideas to help show that, and then make sure you're implementing it, of course, to show that you're meeting the general duty clause. And I'm not going to run through all of these. These are just some pandemic-related safety expectations that OSHA has listed. It's a good list to look at because this isn't a federal agency that can come in and do an inspection. And if 5 of these you're not doing, they may have a problem with that. Let's see. At this point, there are minimum of what these that I just have on that previous slide. There are a minimum of what employers should be doing. Make sure you're documenting steps that you're taking. For example, if you're taking temperatures, asking about symptoms, make sure you document that. Many of you may not be aware of this, but OSHA has an occupational risk pyramid. Take a look at that and see where you fit as a company and an industry within that medium, low, high, or very high. That's something you should be doing because that then links into PPE, which I'll talk about in a minute. Make sure you're doing the sanitizing, workplace disinfecting, cleaning. OSHA logs. So this is going to be a little bit of a challenge in most situations. You know, obviously the meat packing facilities, I think we all can understand that that has pretty much been traced to the workplace. Those illnesses are OSHA log issues. They should be logged. If you have 100 employees and one becomes sick with COVID-19, just one, is that something you put on your OSHA log? I would say no, unless there is some evidence tying it to the workplace somehow, which is going to be a really tough thing to do. But if you have an outbreak, that's when you're really talking about an OSHA log issue, not one or two sick employees. And this may become easier to trace as testing and contact tracing and other measures improve. Okay, PPE requirements. OSHA has issued specific information for certain industries like veterinarians. There is like a chart for that industry and some other industries. But the key thing is understanding where you fit on the OSHA risk chart and then taking a look at CDC and OSHA requirements. The mask issue that I mentioned before, OSHA in the guidance they put out yesterday specifically said that the guidance is not a standard or regulation. It creates no new legal obligations. And so that means something. At the same time, again, OSHA is going to be asking about masks. They'll put out a guidance, and all of you should be at least cognizant of that. Just move on. Symptoms and temperature taking. This would have been a huge no-no pre-COVID. But now the EEOC has specifically indicated through published guidance that you can do both with temperature taking. And by the way, last time it was updated was May 5th. As far as symptoms go, that's likely to be, the list of symptoms are likely to be added to. Again, this is not static. Make sure you're taking a look at the CDC website regularly for things about steps that employers should take and symptoms if you're asking about symptoms. And anything you gather obviously goes in a secured file. Real quick, temperature taking. I do have employer clients that are doing this, and in some settings I think it's a good idea. But if you do it, make sure you do it correctly. It's generally preferred that someone with medical training to take the temperature. Results should be kept confidential. Make sure you're communicating well to the employee about this, that it's not a diagnostic test. You're just checking for a symptom, and hand in hand with that, you know, make sure that you're communicating to employees that the absence of a fever does not mean that they're COVID-free. If other symptoms arrive, they should consider going to see their doctor or being tested. In much the same way, if they do have a fever, make sure they understand that doesn't necessarily mean that they have COVID, but you know, they should probably seek some medical assistance. Make sure you select a temperature, and I usually recommend the CDC's recommendation is 100.4. I've had some clients go down to 100. Below that, you know, it's really questionable if that's a fever because people's temperature vacillates. But if you do take the temperature, set a mark by which people would have to go home, and take it at the start of a shift, or if somebody says they're not feeling well, you might want to take it then. And consider protocols. If somebody says, you're not taking my temperature, what are you going to do with that? Are you going to terminate the person? You're going to send them home on unpaid leave, which then gets back to some of the unpaid leave issues we talked about earlier. Just think about those protocols. And with that, I'm turning it back over to John.
Well, thanks, Steve. For the last little piece of our presentation here, I wanted to go over some potential legal issues or disputes that we either have seen or we think we are likely to see as a result of the pandemic or in connection to the pandemic. And so first, just briefly, we certainly may see Families First Coronavirus Response Act compliance issues. A couple of things that I think have already come up, or I believe certainly will come up, is, you know, how far can employers push if they think that employees are being untruthful with respect to reasons for leave as a way to go ahead and take advantage of some legal protected leave that really they're not entitled to. And so one thing that comes to mind as a result of where we are now in the calendar is, let's say you've got parents of school-aged kids, and, you know, obviously during the school year, they intended on having those kids in school. So if they needed to take time off to care for them during the time that the normal school year would actually occur, that's easier for an employer to accept. But I'm guessing there will be instances, and I've actually come across one of these already, where it seems pretty clear that a parent may not have had set plans for childcare over the summer and is now trying to use the FFCRA as an excuse to go ahead and get some type of paid leave so they can stay home with their kid. How far as an employer can you push that? In addition, I've seen this issue come up with respect to employees who may have certain risks or claim that they have certain risks of COVID complications should they be exposed to it. And how far and how much are you able to go ahead and push that employee for information? The way that the regulations and the guidance state now, they effectively say that if the employee puts his or her request in writing, and they suggest in writing with respect to the FFCRA that they actually have the ability or they are in need of this type of leave, then you as the employer have to accept that representation. I think, and what I've been telling many clients, is that I think employers can go ahead and ask for additional documentation on the front end and see if employees will provide it. So in the case of a healthcare provider who allegedly tells an employee that they are at risk for some type of COVID complication, ask the employee to provide you with a statement from that healthcare provider, and hopefully you will get it. If you don't, or if the employee refuses, then I think pursuant to the guidance as an employer, you kind of just have to let sleeping dogs lie and rely on the employee's written statement that they actually are at risk and a healthcare provider did advise them. Similar situation with respect to the camp. Maybe you can go ahead and ask the employee for proof that they actually had their kids enrolled in a camp or some other childcare over the summer, and as a result of COVID-19, it's been canceled. But if the employee does not comply with that request, I don't know that we as employers are in a position to go ahead and push that much further. Couple other issues that I think could perhaps come up under the FFCRA and things that I have seen come up, making sure that we're paying employees correctly for the leave that they're actually on. For a lot of people, an hourly wage worker who doesn't get bonuses on a regular basis, this is going to be pretty simple. Same for people who are on salary and do not get bonuses on a regular basis. But for people who earn a lot of commissions or there's a lot of premium payments in their time, it is a more complicated analysis to go into. So I can certainly see some employee or some enterprising plaintiff's attorney later on saying, hey, there's this employer out there who had a group of employees and they paid them inappropriately for the 2 weeks of FFCRA leave. I'm going to go ahead and sue, start a class action on their behalf. Maybe we would only pay each of those employees peanuts if we got it wrong, but those claims will come with attorney's fees attached to it. So I can certainly see law firms, plaintiff side law firms, trying to use that as a basis to go ahead and bring suits and get work for them going forward. Finally, with respect to the FFCRA, you want to make sure that, obviously you are claiming the tax credits that you are unable to claim so that you don't actually have any money leave your pocket at the end of the day with respect to FFCRA payments. But you want to make sure that you're doing it correctly and not taking credit for employees who you shouldn't be, or taking too much credit, because then it's entirely possible that the IRS will come calling and you don't want to deal with that. Next slide, Steve.
Hey, John, before I go to the next slide, take a look at the question that came in. I think it might be a good time to answer that question.
Okay. Could you explain more about concurrent leave? Specifically, if an employer provided special paid COVID leave, can the employer require an employee to use that leave concurrently with FFCRA leave, or is the employee entitled to use the special employer provided paid leave first and then also have the ability to use the FFCRA leave? So the FFCRA specifically says in it that if an employee qualifies for FFCRA leave, the employer has to give that employee the right to take the FFCRA leave first. So this is an issue that I found with a number of clients came up back right before the FFCRA came into effect, and then thereafter, employers, some had started creating these new buckets of leave with respect to employees who wanted to take time off, not knowing that the federal government was going to pass something, or notwithstanding the fact that the federal government was going to pass something. The federal government then decided that the FFCRA leave has to be taken first if the employee wants it to be done that way. So those leaves would not run concurrently. You'd have to do them consecutively unless the employee otherwise told you differently. The FMLA, the regular FMLA, as I mentioned before, that can run concurrently with the FFCRA so long as the reason for the employee's leave satisfies the FMLA, the regular FMLA. So hopefully that answered the question. Steve, did you have anything else on that?
Nope, nothing to add.
Okay. So potential legal issues and disputes with respect to the FMLA, the regular FMLA, the ADA, and Wisconsin Fair Employment Act issues. And I have to say, just as an aside, one of our good marketing folks went ahead and added some pictures to make this presentation look a little bit better. It's been a number of months because we've all been working at home, but I think that is the inside of a courtroom. Steve, can you confirm?
Yeah, I'm not sure. It's been a while.
Okay. Well, in any event, at some point, maybe we'll get back there. But with the FMLA and the ADA, really the thing that I wanted to mention to you first is, especially in light of the circumstances where we're in, and employees are being faced with these new circumstances. Employees are fearful, some more so than others. Employees may not necessarily be willing to follow, or just may not be aware that they're supposed to follow these normal processes that I'm assuming a lot of you have in place for requesting leave pursuant to the FMLA, or requesting an accommodation pursuant to the Americans with Disabilities Act. Certainly one thing that I have counseled employers over the course of years is to try to have a standard process where these requests are routed through HR. And I think that still needs to be the case. You need to have some type of point person or point department where these requests go so things don't get lost. But at the same time, supervisors, frontline supervisors, people in the crew in the factory, people who are the head of teams, they may very well get requests like this, even though we want the requests to go through HR or a specific department. And when those requests happen, we as employers still have the responsibility to deal with them. So I think this would be a very good time, if you haven't already, to go ahead and reiterate to your supervisors that they need to have open eyes and open ears with respect to potential requests for accommodations, and give them examples of what that could potentially look like, so that if and when they get it, they go ahead and provide that information to HR, and HR knows what to do with it. Because what I don't want to see happen, which I think possibly could, is you have an employee who makes several statements to a supervisor about needing an accommodation. The employer just misses it because it didn't get to the correct source. And then you're faced with a claim for failure to reasonably accommodate later on. The other thing that I wanted to mention is the second bullet point here. Can an employer who permitted employees to work from home during the Safer at Home order get away with arguing that physical presence is actually necessary and essential now? That I addressed a little bit beforehand. I think it's important to just reiterate, I think this issue is going to come up. I have already talked with clients about it already. I think you're going to have to deal with this to some degree on a case-by-case basis, but especially for the next 6 months, potentially more, a year, depending on how far this pandemic goes and how long it lasts in its current form, employers are probably going to need to be a bit more open to teleworking. And I know most of you, if not all of you, are. But that's something that, it could end up being something of a new workplace model that continues for a while. And as employers, I think we need to be aware of it and open to it. Next slide, Steve. So got a couple more things here. Wage and hour potential claims. There's a couple different scenarios here where I think this issue could come up. One is if you are an employer and you have been allowing non-exempt workers to work from home. One thing that I think Steve and I and everybody in our employment practice group always want to tell employers is that it is somewhat risky to have people who are working by the hour, non-exempt, putting in hours outside of the office where you can't track them. As a rule, we have to pay them for every hour worked, every minute worked. We have to track that time. So for example, giving somebody who is a non-exempt employee the ability to check their email when they're outside of the office is risky. Obviously, there have been situations in the last few months where there will be, just for the sake that, we had the safer at home order here in place, there were non-essential businesses that were shut down. And to the extent that you could have employees working from home, you wanted to do so, so you could continue to have production and so your business wouldn't completely shut. There could very easily be liability from employees who say that they ended up working more hours than we thought they did. Going forward, if you're going to continue to have people who are non-exempt working from home, you have to figure out a way, if you haven't already, to try to track their hours. You have to have some type of an agreement that the employee is only going to work between certain hours that you're aware of, or have some type of timing system so that if they log on to a computer, for example, you know when they log on and when they log off so you can track the time. In addition, we need to be cognizant of potential impacts of working at home or reduced hours on people who may be exempt. Certainly, there are people who may have suffered through some type of loss in salary as a result of these current circumstances, as a way for an employer to try to conserve funds. I know several clients who decided to go ahead and do across-the-board cuts with respect to certain of their personnel so that they could more easily get through this time period. Well, I think beginning this year, I think January 1 of this year, it's kind of gotten lost in all sorts of other employment-related news and just the news of the world. But the threshold, the salary threshold for the white-collar overtime exemptions was raised to a little bit over $35,000. So you need to be cognizant that if you drop somebody's salary, you didn't drop it below that number, because if you did, you may have lost the exemption at least for a period of time, and you're going to have to be careful to earn it back. There might be some overtime liability in the meantime. Plus, there is a potential Wisconsin issue here too, in that Wisconsin has slightly different rules for its white-collar exemptions. And I know some employers who had to let some people go, and then as a result were asking other people who remained to do more work, to do additional jobs than they ordinarily would. Well, Wisconsin says that for somebody to remain exempt, they can only perform a small percentage of non-exempt work. Otherwise, you risk the exemption from going away and then requiring to pay those people overtime. So if you have a supervisor who normally would obviously be exempt because they are effectively directing other people what to do, but then you cut somebody below them and they have to do some more of the work that they would ordinarily manage somebody else to do, you could be putting that exemption at risk and then also find yourself open to some type of overtime claim. So I would be careful of that. Finally, I wanted to go ahead and touch upon, really, this is kind of two issues that I'll try to run through quickly because I know we're almost at 9:30, and I wanted to see if there were any other questions that we could hit too. Potential liability to third parties. Steve and I have kind of mentioned workers' compensation already. Most likely, there's not going to be too many instances where an employee, even if they get sick as a result of COVID exposure at work, would be able to sue the employer for negligence. That's most likely going to be covered under workers' compensation. There could be penalty claims attached to such a claim if the employer does not take appropriate steps to deal with it. But odds are most claims are going to be covered by workers' compensation. You're not going to have to deal with outside liability. But there certainly could be situations where there are employees who work for you who could potentially expose other people, or you've got visitors who come into your facility and could be exposed. There could be liability associated with that. And it could just be strict negligence types of liability. And I can think of a number of different ways how this could come up. One that comes to mind is if you have a salesperson who somehow gets sick and that salesperson continues to go door to door to other places while they are sick and have symptoms, conceivably there could be some type of liability that comes back to you as his or her employer for not preventing him from doing that and not quarantining for a period of time. I had an example, or I had a couple of questions a few weeks ago about, well, can we have our employees or can we have visitors enter into some type of a waiver to try to protect ourselves from liability? Quickly, with respect to employees, I don't think waivers of that type are a good idea. I also don't think that they are effective. Can certainly go into details about that if you're curious about it offline. With respect to visitors, I think some type of waiver could be something that you might want to consider if you have a facility where a lot of people who are not employees may be going to. You could potentially have them sign a document saying that I waive any and all rights from exposure, or I accept the risks of coming here, something along those lines. that could potentially be useful. The last thing that I
John, can I add one thing to that?
Yes.
Just keep in mind on the waiver of liability issue, the Wisconsin courts do not look fondly at liability waiver agreements. So you might have one, and maybe that prevents somebody from filing a claim, but generally speaking, Wisconsin courts do not like them, especially if they are just boilerplate in nature. Somebody comes in, they just sign it without really looking at it. That type of waiver agreement, it's probably not going to protect you very much.
No, that is an excellent point, but I think it is fair to say, as you did, that it could act as a deterrent from people even thinking to bring claims, and for at least that reason alone, it may be something you want to consider. But Steve's 100% right. Wisconsin courts generally do not look kindly on that. The last thing that I wanted to mention, I've just actually read about it a little bit in the last couple of days, and perhaps some of you in the audience have seen this too. But there's been a couple of businesses, and McDonald's in particular, that I saw was actually sued, I think in Cook County, Illinois, in state court by some employees of the McDonald's and their families with respect to an alleged public nuisance. The allegation is that McDonald's did not take appropriate steps to go ahead and help protect their employees from the spread of COVID-19. And at least till this point, the court has not gotten rid of the case. Apparently, this case was brought against first the McDonald's franchisee, so the actual employer of these people, and then the McDonald's franchisor, or the franchise itself. And I think as a result of that, the attorneys are trying to get it past workers' compensation liability. I don't think there's any damages that can perhaps result from this case, but they're asking the court to impose some type of an injunction requiring the restaurants to go ahead and take certain steps that they allege have not been taken. Obviously, on top of that, there's also bad publicity that can result from this. So even though there might not be direct damages liability to these employees, there certainly are other things that could come across from this. But I think this issue in and of itself, this public nuisance issue, which is frankly not something that I have seen brought against an employer in this type of a context before, just goes to show you that plaintiffs' attorneys are going to be as creative as they want to be, or as they can be, with respect to potential claims. And, there's certainly some things that we as employers were not going to be able to foresee. But with respect to some of this stuff, we want to take all of the preventative steps that we can reasonably take to put us in the best position to try to avoid these things from coming up in the first place, because there will be some examples of plaintiffs' attorneys bringing some crazy claims that we think we shouldn't have to deal with and may not have thought of, but we will at some point have to do something with them. That is all of the presentation that Steve and I had.
I'm
have any other questions.
Yeah, a question came in through chat, but one thing I will just piggyback on that last comment. A lot of what we've talked about today is about basically trying to limit risk in lots of different areas. As anybody that's been involved in employment law or HR knows, eliminating risk is next to impossible, because we have a very clever plaintiffs bar out there, and the COVID situation has just presented more potential opportunities for that. So with that being said, this is more a question for you, John, so I'll let you answer it first, then if I have any further thoughts. But the question is, what about, and this is FFCRA related, under reason number 5, what about a parent that has camp canceled for their 12-year-old, but the spouse is still working from home, and the grandparent lives in the same house and is retired?
Yeah, no, that's an excellent question. I think you and I actually talked about a very similar situation a few weeks ago. And I think ultimately what we decided, and obviously you can go ahead and jump in and tell me otherwise, is that if the employee asserts in writing that they actually need to take the leave for whatever reason, maybe their spouse who's working from home can't watch the kids, maybe the grandmother is not capable of watching the kids, who knows? If you get that thing in writing, you almost certainly have to provide them with the FFCRA leave, because otherwise you could be faced with a risky claim. You could certainly try to push that person to a degree, but ultimately I think if they want to rely on that written statement, you as the employer likely have to give them that leave.
Yeah, I agree with that. The only thing I would say is I think it is okay to say, well, your mother is living with you at home, is she a possible, person who could provide care for the child, at least some of the time or something like that, and have that conversation. But if they just say, nope, that's not going to work, I agree with John. Then you're probably looking at having the FFCRA. Couple more questions that came in. The first one, if you have an employee that becomes positive with COVID-19, are there certain questions an employer should ask to document an employee's outside exposure through parties or large gatherings? I'll take first crack at that one, John, and then obviously you can add to it. How much do you question a single employee that has COVID-19? Unless they are saying, I know I got this from work. I just don't think that a single incident is going to expose the employer to much that I would get into a lot of questions that could get into some maybe privacy issues and so forth. On the other hand, is it fair just to sort of casually say, how do you think you got exposed to this? I suppose you could. You also might be able to find something on, again, social media that will answer this question without you having to even ask it. But I'd be a little bit careful going down that path. I'm not saying you can't, but I would just be careful and only do that in certain situations. John, what do you think?
Yeah, no, I agree with that completely. I guess one thing that I would add is, if you do have an employee who becomes positive and this employee has been in the workplace in the days or maybe week leading up to when you get the positive test, you as an employer need to try to see what other employees that person may have been in contact with, and then have discussions with those people and decide internally, do those people need to quarantine for a period of time? Do they need to go home? I think that's probably a bit more of a critical issue than determining exactly how an employee may have been exposed outside of work. But certainly these are all important things that we frankly never thought that we would have to deal with until 3 months ago.
Yeah, agreed. Another question, it's FFCRA related. What about an employee who has an adult child with autism living with them whose vocational center is closed during the day? Again, a 14-year-old child under 14 years of age, that's where you're really looking at reason number 5 under FFCRA. I'm not aware of anything that particularly would be covered by FFCRA with an adult child. John, your thoughts on that?
Yeah, I think the age restriction might go a little bit higher than 14. I have not looked at that in the last couple of weeks. For some reason, I thought it was defined as being older than that. But if you're talking about somebody who is clearly like in their late 20s or 30s, I don't think the FFCRA would apply. And so then the employer is just going to need to try to find a different way to deal with it. It's going to be up to them. But as far as legal obligations, I don't think there's going to be any legal obligation for the employer to deal with that. But certainly you can try to work with the employee to come up with different ways to try to handle it if you want to.
Yeah. And my recollection is that for school-age children, if it's 14 years or younger, I think it's sort of a default automatic protection if the schools are closed. I think if it's above 14, it would require some special situation, maybe a special needs child or something. That's what I seem to remember reading at one point in the Q&A from the DOL.
Yeah, that sounds familiar.
So I don't see, make sure, yep, those are all your questions. We are also a little bit over, it's 9:40. Obviously, if any of you have follow-up questions, you know where to reach us. So we really do appreciate your attendance today. John, any final closing comments?
Yeah, thank you everybody for attending. We really appreciate it. I think, assuming, we certainly would appreciate your comments and let us know how this works. I know in the past, DeWitt has done more in-person stuff. Obviously right now we can't do the in-person stuff, so webinar makes sense. But at the same time, if you guys really enjoyed doing the webinar way, we can try to do more webinars like this. So certainly, if this is something that you like this format, let us know, and we can try to get these out there more frequently so that it might be easier for you to attend if you're interested.
Yeah, I agree with that, particularly for some of our clients who are a good ways away from Madison or our Brookfield area office. I'm glad that you were able to join us. I know there are a number of you out there that normally can't come to our HR roundtables because it would require a lengthy drive and probably an overnight stay. So I'm really pleased we're able to do this format. And I agree with John. Any comments on this format or other things that came up, please share that with us. We'd love to hear from you. Thank you. Everybody have a great day.
Thank guys. Take care.
Bye.